Hello, once again. Welcome to the Law Professor channel where we discuss different aspects of law. Today's presentation will focus on res ipsa loquitur. Res ipsa loquitur. And in this presentation, we shall be looking at what that maxim means and how it is applied in the thought of negligence. Don't forget, once again, to share this video and subscribe to this channel, The Law Professor. Res ipsa loquitur comes under the proof of negligence. Proof of negligence. We have established in previous videos that the plaintiff must establish by evidence that negligence has taken place. The plaintiff must establish by evidence that negligence has taken place. The burden of proof ordinarily rests upon the plaintiff who comes to court and claims that the defendant has been negligent. However, in some situations, the law would infer negligence from the facts of the case. The law would infer negligence from the facts surrounding the case. And therefore, we want to look at situations where this inference will take place. The maxim res ipsa loquitur means the fact speaks for itself. The fact speaks for itself. And what you're saying is that from circumstances of the case, the facts of negligence can be presumed. From the circumstances of the case, the facts of negligence can be presumed. I'm trying to share my screen. And okay, so when can we say the fact speaks for itself? That's the meaning of that Latin maxim, literally. When can we say that? And what does it do? What does it do when you say the fact speaks for itself? Now, when you are able to apply res ipsa loquitur, you remove the need for a plaintiff to come to court to prove the particulars of that negligence, how the incident took place, how the vehicle veered off the road and came to hit a pedestrian walking on the opposite direction, or left his own lane and when it came to the other person's lane. Since such information would ordinarily not be in the possession of a plaintiff in court. So the law would remove that burden and shift it to the defendant to establish that he was not negligent. So the inference of negligence is raised against a defendant. So it is a rule that removes the it's an evidential rule that places the burden on the defendant to establish how the event happened without his negligence. In Scott and London and St. Catherine's Dock Company, the court held that where the thing is shown to be under the management of the defendant or his servants, and the accident is such that in ordinary course of things does not happen, if those who have the management use proper care, it affords reasonable evidence in the absence of explanation by the defendant that the accident arose from want of care. I also see the case of Brian and Bottle in that regard. The elements that we can pick from this statement have as follows. The accident causing item is under the defendant's control. It's under the defendant's control. Two, that there is lack of explanation by the plaintiff. And third, that the accident does not ordinarily happen without negligence on the part of someone, the defendant, for example. And we must note that the cause of the damage, that second element, is very important. It must be unknown. Now, accident is on, the first element, it's under the control. Maybe the vehicle, for instance, that caused the accident, the bag of cement, the process of treatment, whatever may be the basis of complaint that there is a breach of duty, you must establish that that was under the control of the defendant or his servant. If it's under the joint control of the defendant and other people, you may not be able to raise the inference of negligence against the defendant exclusively. There must be no doubt, therefore, that whatever is the basis of the complaint was under the control of the defendant. For instance, if you are an occupier of a building, you know that you're in control of your premises. If you're a vehicle driver, you know that you're in control of the car and what have you. The lack of explanation is very critical as a second element. If the plaintiff is able to come to court and demonstrate to the court how the event occurred, if there is evidence of how the event occurred, if the pleadings depicts that this is how the event occurred, then there will be no reason to infer negligence, to presume that negligence, to take an inference of negligence. the court will rely on the evidence before it. So there will be lack of evidence, lack of explanation about how the event took place. How did the bag of flour fall from out of a window? How did the bag of cement fall through a door of a building and hit a pedestrian on the road? If there's explanation about how it happened from the plaintiff, then it will not apply. Then you must show that these are things that ordinarily in life, in the experience of man, they do not happen unless someone has been negligent. Things like this do not happen. If there are things that could happen anyhow, anyway, you cannot infer negligence. There must be clear and demonstrated knowledge as to the fact that this kind of event does not ordinarily happen. People don't go driving a vehicle and without some negligence somewhere, the vehicle skid off the road. Is that the driver was not paying attention, the road was slippery and was not driving at reasonable speed, or what has happened? People don't complain and say, oh, I have a bad eye. And by the time they go for surgery, they become, they have lost both eyes, or they go to surgery with one stiff finger and they come out with 5 stiff fingers. So the court must be satisfied that what has happened is something that ordinarily it does not happen if there is no negligence. Then that is the only basis for the third principle to apply. Case law examples would give us clearer illustrations. Scott and London and St. Catherine's that gave us the elements where the bags of sugar fell through the building and hit a pedestrian on the road. The court said these bags of sugar, they don't have wings to fly out of a building and come eating someone in the street. Someone in custody of the bags of sugar has been negligent in the way they kept it. The same thing with buying and bottle where bags of flour fell out of the door of a building and hit a pedestrian on the road. In Mahon and Osborne, where you found cotton wool in the stomach of a patient that had gone for surgery. Cotton wool doesn't just appear if the medical team hadn't been negligent during the surgery, or where someone went for surgery because he was complaining that he had a stiff finger, he came out of the surgery with 5 stiff fingers. Now, ordinarily, these are plaintiffs that would not be able to tell us, but this is how it happened. This is what the doctor did that made cotton wool to be left in my stomach, or this is what they did negligently in the course of the medical procedure that made 5 fingers now to be stiff. So the court will now place the body. After all, the defendant that had custody of this thing, whether an item or a process or an event. Explain to us how this happened without your negligence. So if this is done, then if these 3 elements are found, then the court likely to apply it. You have other case law examples with someone walking on the road and being hit by a vehicle. The person is keeping a proper watch out, is walking on the pavement, and the vehicle leaves the road and goes to hit that person. The victim would be unable to tell the court what actually happened that made the vehicle to skid, to leave the road and come and hit him, or a driver that hits another from the front, from the back. The court will presume that somehow the vehicle that hits someone from the back, the driver has been negligent, because vehicles do not propel themselves. Somebody is in control, is in custody of the vehicle and is driving it. So these are some of the cases and examples of cases where the law has been applied, the maxim has been applied, because it's not a substantive law. It's actually an evidential rule that shifts the burden from the plaintiff to the defendant. The effect of res substitutor is that if the court applies the maxim in favor of a plaintiff, then it shifts the burden, like I said, to the defendant. And if the defendant is unable to disprove negligence, then the defendant will lie in the thought of negligence. The defendant could disprove negligence by showing that, well, ordinarily it doesn't happen. Bags of sugar do not fall off buildings. Vehicles do not skid from their lane and face opposite direction and hit somebody that was hit another vehicle. But ordinarily, but in this context, there was an earthquake, and that was what propelled this item out of my control. So if he's able to give that kind of explanation, then he has to be able to show that this is an act of God. Or if he is able to show that he had exercised reasonable care. And despite it, a reasonable person still have been unable to prevent this event from happening, Then you talk about inevitable accident as a defense, and then the defendant will not be liable. So the implication of the maxim will depend on what evidence is now available from the part of the defendant. So this is the this is a brief summary, therefore, of the maxim, the Latin maxim res ipsa loquitur. What it does is that it obviates the need for the plaintiff to prove that how the breach of duty caused the damage to him. It shifts the burden of proof from the plaintiff to the defendant. And what would happen eventually in terms of liability would now depend on what the defendant is able to establish also before the court. Don't forget to like the video, to share with your friends, and to subscribe to this YouTube channel. I'll see you at the next presentation.